have director as we have director as a rank. Director as a rank. Where if you go to ECG, you will see director for commercial director. When you go to Cocoa Board, you find director of finance. You go to VRA, director of this, director of that. That is not a director we are talking about when we are reading this act. That's what it means. For the purposes of this act, director means those appointed to, direct and administer the business of a company. So when we talk of directorship, it is not the rank of a director that you can move from, let's say, deputy manager to another rank and another rank, and you end up a director. Or there's another rank that from there you go to deputy managing director, and then if the opportunity presents itself, you can be a managing director. That is not what we're talking about. A director means a board member, simplicity. So let's get that understanding. Now, the reason why I'm taking time to explain this is that some people know that directors, and the director as a rank, they are the people who administer companies. And they will tell you that the job of a board member is not a day-to-day. Therefore, when they hear the director administers a company, they want to assume that we are talking about that kind of director. No. We are talking about a board member. So one, this is the narrow scope of director. In this act, it is those people appointed to administer or direct the business of a company. Then you have to ask yourself, appointed, who appoints them? Let's not worry about who appoints them now, but you must be appointed. And you must be appointed through a letter. You must be appointed through a letter. And you must respond to that letter through writing. So if you want to appoint somebody to your board, you just don't meet the person. Yesterday, I got a text message. Somebody wants me to be on his board. And he sent a text message. And I said, okay, we'll have to talk further. And then use the proper procedure. And I wouldn't have said that if he did not say that they have decided that they want me to join their board and they are meeting next week, so. So I ignored that part. The point is that there is a clear procedure, and we will talk about that. If you don't fulfill that procedure, you have not been duly appointed. You may have been appointed, but not duly appointed. Now you have to be duly appointed, even though people use verbal means to invite people to meeting and all that. We will probably, as a very small country, we would get there. And that's why some of you must know what is right and advise accordingly wherever you find yourself. Okay, so you must be appointed and to direct and administer the business of a company. And by extension, if you look at those two words, direct and administer, we are talking about the vision and the mission of the company, ensuring that the vision and the mission of the company are achieved. The vision is a long term, which is the direction you are providing. And those are provided through strategic decisions, strategic plans, policies, things that last longer. Things that last longer. If you set a path that lasts 5 years, 10 years, that's a direction that you are providing for the company. Then administering is ensuring that the reason why the company is in business is achieved. And that's the mission. So that section 170 is deep. And I want us to take it again. So John, just repeat for clarity.
All right, sir. So 170, for the purposes of this act, directors means those persons by whatever name called who are appointed to direct and administer the business of the company.
Okay. So that is simply a director. Now we know that we are not talking about the director at our workplace. We are talking about the board members. Now let's go to the next section,
Subsection 2. A person not being duly appointed director of a company, who holds out as a director or knowingly allows to be held out as a director of that company.
Okay, let's stop here. If you are not duly appointed, like somebody inviting me to their meeting, if I go to that meeting, I'm not duly appointed. But they will count me as a director because they've invited me and I've come. So they will count me as a director. When I walk into the meeting and sit down as a director, I am holding myself out as a director. A person not duly appointed who holds himself out. Holding yourself out as a director means that you are making people believe that you're a director. You are telling people that you're a director. Or you allow yourself to be held out. This time you are not doing it. Others are doing it. And you allow yourself. It could be that you're walking around the premises and people are calling, director, and then you are waving. You are enjoying the fans. That is holding yourself out as a director. It could be that the company was doing something fishy. They put your name there as a director when you are not duly appointed. And you agree, you ignored it. You are allowing yourself to be held out as a director. Your term has expired. You keep on, sitting on the board. You are allowing yourself to be held out as a director. And you are also holding yourself out as a director. You are a de facto director. A de facto director. You have not been duly appointed. But everybody calls you director. Everybody sees you as a director. You parade yourself as a director. You are a de facto director. Now go to the next one.
Or B, on whose directions or instructions the duly appointed directors are accustomed to act.
Yes, so you are picking this from the other preamble. Any person who has not been duly appointed and on whose direction the duly appointed directors are accustomed to act. What it means here is that you have not been duly appointed. But when duly appointed directors are going for meeting, they will call you for advice. Or when we go, we will discuss the managing director's issue. We want to sack him. We will discuss the issue. Today we want to take a decision. What is your take? And this person who is not a duly appointed director, who doesn't sit on the board, is giving directions of how to go about it. He's giving only advice, speaking his mind. And that mind is going to be executed by the person who called him. So when he's at the meeting, I say, oh, the former board chairman even said this, that we should treat it this way, this way, this way, this way. And they say, oh, if the former board chairman has said it, then that's it. Let's follow that. That means that duly appointed directors are accustomed to following your instruction. Or they are in a meeting, they are in a fix, former managing director, they call him. Or a politician who helped them to be on the board, they call him. It could be anybody that they have some level of respect. It could be a chief. It could be. That is a major board decision, and they are asking for somebody's opinion, and that is the opinion they are going to execute. When there is somebody like that, that person is a shadow director. And that shadow director and the de facto director, they have not been duly appointed, but they have influence and they parade themselves as boardmen, especially the de facto. Unfortunately for the shadow director, sometimes he doesn't want trouble for himself. He has had an accomplished career. He's retired. He's sitting somewhere. The calls keep coming because of his knowledge. They call him. If NDC is in power and there is an issue at GMPC, at the board meeting, somebody can suggest, let's call Chachu. Let's call Chachu. Oh, Chachu is the longest serving managing director of this. Chachu has been the chairman of the board. He has been the CEO. So what is it that he doesn't know? Let's call him. And when you call him, he will give his opinion, of course. Every person who has gone through such experience is happy that he is consulted. But if the decision backfires, then let's read the next part.
So such person or such a person is subject to the same duties and liabilities as if that person were a duly appointed director of the company.
Okay, so that's the nonsense about it. If you do that and there's a liability, when they are surcharging the duly appointed directors, and they manage to say that, oh, we acted upon the instruction of ABC, that ABC would be also in, the liability extends to the shadow director or the de facto director. So take note of that. Okay.
Clause 3.
Any questions? Any question from there before we go?
So, Doc.
Yes.
I recall that there was once this matter in Ghana, the quality grain scandal. Sometimes, yes, where Professor Mills of blessed memory was identified as a shadow director in that case because he was, it was the then NDC government that the quality grain issue came up. So that when that board or that whole business was being put up and the company was incorporated, they were still receiving advice from the then Professor Mills, the then Vice President Professor Mills. And so in that case, he was identified as a shadow director of that company.
Yes, you see, but the good thing is that both Chachu and Mills were directors. They were lawyers. Even though Chachu was not involved in the quality grain, at a point his name came up. The issue of Mills was also that it was a pre-incorporation advice. And pre-incorporation advice can be given to a promoter. It can be given to a proposed shareholder or anybody at all. And at that time, I think Mills was the commissioner for GRA. And if anybody is trying to promote a company, he wants to look at the best way that he can minimize his taxes and all that. I hope you understand that. So
Yes,
that was an expert opinion that they wanted. And he thought that, yes, it started from pre-incorporation, and there was nothing wrong with that. But when it came to the other ministers who were jailed, those ministers were jailed not because they did anything wrong, but the quality grain, a lady from America came with a proposal during the NDC time that I want to grow rice that can feed the whole of Ghana. Ghana can stop importing rice. That sounded very nice. I have seen a loan that a person who wants to do that can apply for. And I intend to apply for that loan. All that I need is a guarantee from government of Ghana. So the government of Ghana is not going for the loan. I am going for the 20 million loan, and I am using the 20 million loan to grow rice in Ghana. All I need is for the government of Ghana to guarantee the loan. So Minister of Agric was part, and then the Minister of Finance was part. Then George Sipayanki was, I think, Director Legal, Minister of Finance at that time. Either Director Legal or Chief Director was part. And through that group, and then the Minister of, the Chief Director of Minister of Agric, who was later acquitted. So, story short, the guarantee was given. The girl got the money. And then she kept coming to Ghana. Occasionally she would hire a helicopter and they would go to the site. Some rice cultivation started, but not to large scale. The land had been acquired in the Volta region. Then all of a sudden, we heard that American government was putting the lady on trial. Why? Before two participants, your hands are up. I can't see the hands up, so I can't see them. So if your hand is up, you can ask your question. Hello? Yes, if your hand is up, you can ask
like
the
you are
question.
saying,
Okay.
like you are saying, with regards to the shadow directors and the de facto directors, they are not officially appointed to direct the company or the institution. Why is it that when they offer their opinions or suggestions or whatever or directions, and when there is a liability, you can fall on them or you will link it to them by extension, though they are not officially appointed to manage the institution or direct the institution.
Yes, but when it succeeds, you see, the annoying thing is that when the advice succeeds, they don't get anything. When the advice succeeds,
then there shouldn't be any
want to pay them. Yes, that is the beauty of the law. If you prefer the advice and it becomes successful, you don't gain from it, because on what basis are they paying you? You are not a consultant. You are not. No, they are not paying you. But if it goes bad, then it will be traced in the chain. And if you like, I don't know where you work. Even today, if you like, if you are a government appointee or somebody who receives government subvention, you take government money that's meant for the running of the business and invest the government money in whatever investment you want to do. If it yields results, you will be praised. Oh, he has grown the company, he has done this, he has done this. But let it backfire. Then they will ask you, which mandate did you use to invest government money? Were you employed to come and run a business? You can try that one. That one, you will see how the auditors will question you. Go and invest government money and let.
So, sir, in this context, can we say that the law is not fair? Because if the thing goes well, if I don't benefit or won't get anything positive, then why is it that when there is a negativity, you can link it to the person who just offered that shadow advice or whatever?
The law is telling you that you are not duly appointed. You are not duly appointed. That's all. You are not duly appointed. Don't go there.
All right. Thank you, sir. Thank you.
Okay, thank you.
Okay.
Prof, Doc, good morning.
Good morning.
Doc, I want to be like you so that any question they ask me, I know everything.
I want to be like me.
Yes, please. So that I'll know at least something about anything. So,
who says I know everything?
Yes, Doc. So far,
I don't know everything.
There's something about everything.
The things that you know.
Yes.
The things that you know.
Yes, Doc.
I may not know half.
Okay, Doc.
You may know all the players of Asante Kotoko. I wouldn't even know the goalkeeper.
Doc, you end up knowing some history about it. Okay, thank you, Doc. I heard a businessman in Ghana told me that if you bring a business to the government of Ghana as an individual, a foreign business, that you are entitled to some percentage, and that was established during President Kufuor's regime. So once government starts that business, you have a certain percentage. He even said 10%. And he argued to the extent that he wanted to say it was a law or a policy established. So I want to know if, Doc, you have any idea about that.
It may be a convention that they follow, and they may follow because someone can refer to another person's benefit. But I doubt whether this can be written in any document for Parliament to approve. What I know is that at a certain point in governance, and Rawlings used to do that, when Rawlings was supposed to go to return to democracy, it was 1987 that Rawlings was asked to return to democracy. And then he said, okay, the people are not ready for democracy, and that kind of military talk. Then, to the extent that they brought money for elections, and instead of doing the national elections, they rather conducted the assemblyman elections.
Yes.
And then the people said, this is not what we are looking for. So Electoral Commission, at that time it was called NC, the National Commission for Democracy, had been established. At that time it was the first Speaker of Parliament, D.F. Annan, who was, heading it. And then they decided to do, something, a replica of voting, which was assemblyman voting, and wanted to pass that as democracy. And the people said, no, we want democracy at the national level.
Okay.
So generously, the people brought back some money for us to do that. And that was what kickstarted the Consultative Assembly for us to draw a new constitution and all that. And unfortunately, the Bar Association boycotted because Rawlings in his, we never go sit down approach appointed, he wanted the constitution to be all-embracing. So they appointed every association that existed in Ghana. Chop Bar Association, they had a rep. Hairdressers Association, they had a rep. And the Bar Association thought that this is a serious business. We are going to talk about Constitution of Ghana. What kind of people are you bringing there? So in case of any form of voting and all that, then you have the masses voting on behalf of Rollins. So this, okay, we wouldn't have anything to do with this. That's probably, and then Rollins went ahead with the people that he had.
Yes.
At the end of the day, we have a constitution which was, I mean, of course, it was a cut and paste constitution from the previous 3 republics, and some they departed from the Third Republic, some they departed from the Second Republic, because the Busia one, the 1969 Constitution, was a Westminster Constitution, the British type, where the Prime Minister is the head of government, and the President is a ceremonial government. President. So Akufo-Addo's father was a ceremonial president. And so in Britain, that ceremonial president was the queen, now the king. And then, because they ran a monarchy, then they will vote for a prime minister who, and the difference between a prime minister and a president is that the prime minister, in most cases, is an MP. He's also a member of parliament. Okay. So that makes him present in parliament almost all the time. And that's why you need a ceremonial president who will go and commission the KVIPs and the pipe-borne water and all those ones, because the president, the prime minister is busy in parliament. So when you see a prime minister at a program, that program is very, very important. Or constitutionally, he cannot delegate, and so on. So the Third Republic, we came to what we are running, the White House approach, where we have the president, the most powerful, and then the vice president. So the vice president serves when the president assigns him a duty, or when the president is not physically present to undertake certain assignments. And then the vice president had some constitutional mandates. For instance, he was the chairperson of the Council of the Military Armed Forces, the Council of Police, the Council of Prisons, Fire Service, and I think Immigration. So that was a constitutional mandate, but not entrenched. So when Rollins and Akar had a fight, and he realized that Akar was sent to the Independence Square, I think it was a May Day, to present the speech of Rollins, because Rollins couldn't go. Then he put Rollins' speech in his pocket and brought his own speech. And everything he read was against the government. Everything he read was against the government. So at that time, in the early 90s, you could see that the Rollins had just, metamorphosized into a civilian president. And at that stage, if your own vice president is against you, you could see the tension in the system. So at a cabinet meeting, after that, speech, Rollins wanted to physically prevent Akar from being at the meeting. And Akar said, no, you can't, because I'm the vice president of the country. I was part of your ticket, and both of us were voted for. So you cannot just push me away. And if any of you have heard the statement, a stubborn cat, that was from Accra, I'm a stubborn cat, and all that. So eventually, what happened is that Rollins had to beat him physically. The description of the beatings were all in the newspapers, because Accra had to tell the press that even when he fell down, he was hitting his groins and so on. And his coat was torn and all. So that was the case. So, learning from that, Rollins immediately had to use Parliament. And at that time, the Parliament was a proper rubber stamp Parliament. When they say rubber stamp Parliament, they never say no to anything that comes from the presidency. People are talking about, for the first time, NDC has this. No. Maybe if you want to talk about competitive, but remember that the first parliament of the Fourth Republic, the MPP boycotted the parliament. So everybody in the parliament, 100%, they were NDC. Except, I think there were three independent candidates, and Hawa Yakubu and a few others. But eventually they were all bought over. So, one against, and that I think they were 99 or so. What effect can you make? So, that parliament changed the the mandate of the vice president to be chairperson, because this person is a dangerous person now. Until the next election, you have to do with him. When you send him, you go and read something else. So, you can imagine how he'll be sidelined. And then it was something that was clear that Rollins had regretted using Accra and wanted him out. So immediately after that, there were scandals upon scandals. Accra raped a lady who was first-year tech student and blah, 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 blah. And it was all over. And so there was every means to get him out of government. But he survived until the next election, when Atta Mills was appointed as a commissioner of internal revenue to be the vice president of Rollins for the 96 to the 2000 tickets. Yes. So Accra's behavior going against the NDC was the reason why that mandate of the vice president was removed. Therefore, the vice president had no constitutional mandate to go and be the chairperson of the council. So what the language changed from the vice president shall be so and so, now they said, as the president would appoint. So if the president doesn't feel that the vice president should be appointed, he can appoint any other person to chair. So that is what it is now. It is the president would appoint. But first it was the vice president shall chair the following councils. So most of these changes that are made in the constitution and other laws, they also have their origin from some experiences that the government, in course of governance, would, meet along the way, and some advantages people would take, and then using that they will change certain things. Okay, so that is the story about Rollins and Accra, and Who is Fidaus?
Please, sir, I'm here.
You said I should do what?
The slide is not being projected, so.
I'm not using any slide. We are having a conversation.
Oh, okay. All right, sir.
I don't even have the sections you are reading. I have not even. I don't have the at 992 in front of me. So I'm only depending on what you are reading from your end. Okay. So are you okay with who asked the question? Was it Cosmos or somebody? Okay.
Oh, I'm okay.
Yes.
Thank you.
So back to the quality grade. The American government put the lady on trial for taking a loan from Ghana, a loan guaranteed by Ghana government, $20 million. This is from American government too. The girl is being put on trial because she has taken money that has been guaranteed by the government of Ghana. And she's blowing the cash in America. And Ghanaian government has not said anything. So the girl, I keep calling her girl, Julian Cotton, is old enough. She was jailed 20 years in America because American business laws has what you call extraterritorial effect. Extraterritorial effect means that if bribery is an offense in America and you come to Ghana to do business as an American and you engage in bribery, you can be tried in America. So it goes beyond their territory. It's not like other laws that somebody will say, has he committed any offense in Ghana? The offense was committed, elsewhere. Why are you bringing him to Ghanaian court? The American laws in business, they have extraterritorial effect. So that is what tried Cotton. And eventually jailed 20 years. That was what Kufuor's government was prompted, that the money is for us. We guaranteed it. If she doesn't make any rights, we are going to pay the 20 million. So if American government, who has no obligation on that loan, has jailed her 20 years, and we are sitting here and those involved, we have not said anything to them. So the Minister of Finance, Anna Rollins, as I mentioned, then the then Minister of Agric, very nice gentleman, and then about 4 or 5 people. Yes, initially it was about 4 or 5 people. I remember the then Chief of Staff was part of it, and then the Chief Director, the 2 of them were left off the hook. And then the Finance Minister, the Agric Minister, the Chief Director of Finance, and they were jailed, I think 2 years, 3 years, and they were to serve concurrently. That was the quality grain scandal. But the interesting part of the quality grain scandal, apart from the Agric side, was that these people who were jailed actually went to America for the ladies' birthday party. So I think the lady bought tickets for them. Obviously, that would be a first class or business class. And gave them souvenirs that were customized. Souvenirs that their names were on it. And in course of the trial, it was said that, yes, you knew that the lady had a guarantee from Ghana. And the kind of birthday party she had in America was, too, how will you say, something that is beyond a normal person. So extravagant.
Yes.
And invited people from different countries. So you ought to have sense that this is our money. So it was that kind of, indiscretion that, the people, somebody borrowed from you, or you gave him her a guarantee, and she's blowing cash left and right, big time cash, and inviting you to attend her birthday party where a lot of money was being spent, and you didn't ask anything. And the rice business was not going on. So eventually they were also jailed. Okay. So these are things about governance, and that is why, for me, I like the storytelling, because in governance, sometimes it is about a decision you ought to have taken that you didn't take. Sometimes it's about discretion you took which backfired. Sometimes it's about, that's what you call the act of omission and commission. You ought to have done this. That's an act of omission. You didn't do it. Or you did this, which you shouldn't have done. And sometimes what you did, you have an explanation for it. But when the time comes and you are being tried, you see that the explanation doesn't make sense. For instance, last week, the fire victims, the helicopter victims, everybody was not happy that they were put in sacks. But those who had to do it had come out with a lot of explanation why the sack was the most appropriate. As to whether the people, accept it or not, that is another thing. You've provided your explanation, but it's still hanging because some people are convinced, others are still not convinced. You see? So somebody will come to government and say, those who did that to our heroes, we want to put them before court. And then all the lame excuses why this was the most appropriate and all that will be an issue. And people will refer to the fact that these are not the first fire victims. But are you saying that in any country where there are fire victims, you put them in sacks? So discretion is important in governance, especially where policies are not available and you have to show leadership and you are using your discretion. In some cases, people will find a loophole in that discretion, and then it never goes away. For instance, in the case of Chachikata versus the Chief Justice or so, when Kufuor came to power, Kufuor was Attorney General, and I think Oredu was the Chief Justice. I think Justice Taban had died and already became Chief Justice. And they established the fast track court. And Chachu went to court and said, there is no need for a fast track court because the fast track court is still the High Court. And the High Court exists already in our books. So why are you going to establish another fast track court as if the judges who go there are different and so on? Provide them with more modernized incentives and so on. There's no need. Start equipping your high courts and they can all become fast So he said it is unconstitutional because the High Court still exists. And the Constitution doesn't give room for a second High Court. So the case went to court. And whilst it was, I think it went to Supreme Court because it was a constitutional issue. At that time, when Rawlings handed over to Kufuor, we had, I think, 10 Supreme Court judges active. So we had 12. One of them was sick. He was sick. He was admitted at 37. So for almost 6 months, he wasn't going to work. Then we were left with, I think, 10. Now, Justice Redu had a certain approach. He empanels almost 9 judges on most Supreme Court cases. Instead of maybe 5 or 7, he would straight away empanel 9 judges. Because most Supreme Court judges, cases, if it's a unanimous, you can't challenge it. There's no point. So, this Chachu case became 5 in favor of Chachu, 4 against Chachu. Yes. So, as I said, there were 10. And 9 were empaneled. Now, when a case goes to Supreme Court and it is challenged, or there is a judicial review, or what you call appeal, you appeal to the same Supreme Court. Almost all the judges who sat on the case will sit on the case. Because we didn't have, then they will add 2 more. Where were they going to take the second person? One was sick and he couldn't come and he wouldn't be able to come. And it would even be suspicious to go and bring him from admission to come and sit on the case. So there was 1 extra. But you needed another person in order to make it 11 so that the judicial review could take place. And if you were government, what will you do?
Hello.
Hello.
I would appoint more.
Yes. That's the only option you have. Otherwise, you have to wait till the other person who is sick becomes well. And this person had been at home for almost 8 months. So you never could tell when he was coming back. So he had to appoint. And he appointed Justice Afre. Justice Afre, for some reasons, when he went to Parliament, everybody in Parliament, you're overqualified, you're overqualified. I think he had risen through the ranks at the Attorney General's Department to become a Director of Public Prosecution, DPP. In fact, DPP is the senior most person in the criminal side, apart from the Attorney General, in terms of the civil servants who rise to the ranks. So he had become a Director of Public Prosecution. And then he had taught in the law school. And during his vetting, he said, all the judges at the Supreme Court, I taught all of them. I taught all of them. All those at the Supreme Court. I taught all of them at the law school. So the Parliament itself called him an overqualified candidate because he was, an accomplished person in terms of the justice system. Eventually, Afre was appointed. Then the 11 people sat on the case. And this time, the 5 people who actually declared for Chachu didn't change their minds. The 4 people who declared for Chachu didn't change their minds. The 2 who joined the 4. So then it became 6-5 against Chachu. And you can imagine what Ghanaians would say. That, Afre was brought in to balance the equation. Even the other Supreme Court judge who wasn't sick, but was not fielded because of the 9. Nobody talked about him. They talked about Afre, who was just appointed, and then he has come to the government side. And it became 6-5. So that puts the rest to the Chachu's issue. Once we get to that level, the judicial review, and you lose, that's the end. You can't go anywhere again. You can't go even if you are right and you appeal to the Supreme Court and they empanel with 2 more judges and you lose. That is the end of litigation in Ghana, because it is in the interest of the Republic for litigation to end somewhere. Otherwise, it will go on and on and on and on. Yes. So that was also an interesting aspect. Okay. So let's agree that when you have a mandate as a person on a board, your consultation with other people on the board is described in law. I mean, other people outside the board. So now you understand who a shadow director is, and that shadow director can have consequences in court. That person can have consequences. When the directors are being surcharged, and a case is made against the shadow director, he can be surcharged. And the law is clear. As to whether you don't get benefits or you get benefits, that is nobody's business. The law says that if you're a shadow director, you will bear the same consequences as the duly appointed director. So remember that. And if somebody serves as a bank, let's say rural bank or some bank, and they go to meetings and they call you for your opinion because you are a financial guru. If you are a financial guru, let them appoint you to their board. They have not appointed you and they are calling you for your opinion, for you to calculate somebody's interest and all those things. Depending on how the person wants to rope you in, he will treat you as a shadow director. And you can go down with the rest. Okay. Now let's go. Yes.
Please, what's the difference with an ex-officio director of a board?
Legally, there's nothing like ex-officio. Legally, there's nothing like ex-officio. It is these associations like so associations, those social clubs and so on.
Like the Methodist Church Ghana.
They find people, sometimes they call somebody executive member, ESCO, member of the executive committee and so on. They find those words, but legally, Ghana, we have the non-executive directors, we have the executive directors, we have the shadow director, we have the de facto director, we have the substitute director and alternate director. So these are the ones we have in Ghana. In other countries, they have what we call the lead director, which we don't have officially in Ghana. The lead director makes sense. He's usually the senior most or the person who has stayed longer, and he he acts when the chairman is not present, and so on. But in Ghana, we don't have it in our books. So you can decide to introduce a legal director in your board membership, but it doesn't have any legal effect. Yes, the hand is up. So if you're, and no name is accompanying the hand. So, is it Dennis?
Yes, please.
Okay, go on.
So, Doc, I want to, the example you gave with regards to the Chakchus case like this. By then, couldn't he have taken the issue, since there was no appeal process here, couldn't he have taken the case to the international courts for example?
There's no appeal process where?
When we had challenges with the judges to set on appeal, couldn't he have taken it?
No, that was an internal issue with the Chief Justice and his panel powers.
Oh, okay.
The Chief Justice has to empanel 2 more judges to listen to an appeal. And he has to go to the president and say that I'm short of Supreme Court judges. You see, the thing about Supreme Court judges, the Constitution says that there shall be 9 Supreme Court judges, a minimum of 9, including the Chief Justice. That's what the Constitution says. It doesn't say the maximum. So a mad president can appoint 200 Supreme Court judges.
Oh, okay.
There's no upper ceiling.
Okay.
There's no upper ceiling. But because the Supreme Court judges are expensive.
Prof.
Yes.
Prof,
because
with regards to Dennis' question, he is trying to ask if after the appeal at the Supreme Court, the case wouldn't have been traveled to external courts for determination.
To talk about Ghana's constitution, which court external?
That is, you see, currently, as we are experiencing
the international court or whatever.
The issue of the Chief Justice like this, where it's more or less like it's becoming a problem now. The Commonwealth Court has come in directing the president to do something, but
they only have persuasive effect. Persuasive effect. You can persuade the president to do it. They cannot force anything. You see, the Constitution of Ghana, litigation ends at Supreme Court. Finish. Supreme Court, litigation ends. And it ends, especially with the appeal. Once you appeal and it ends. There are other laws that we have ratified, and it has become part of our municipal laws. If there is war in Ghana, or even the Boko crisis, and somebody identifies a group as the people who are causing the genocide, and government of Ghana is aware, and we are not doing anything, somebody can go to the International Criminal Court. And that's the criminal part, because genocide is part of the international things we have ratified, and people would want to pursue them. But the international court will not come here and arrest them. They will expect the government of Ghana to submit the people. So if you're in the good books of government, you won't go. Some presidents are wanted. Are you aware of that? Some presidents are wanted, but can you go to his country and arrest him?
No, please.
Yes, but when America wanted Noriega, the president of Panama, when America wanted Noriega to be tried, they went to Panama and arrested him. They arrested him. And he was tried, and he's still in jail if he hasn't died. You see? So, the international court, it works at the governmental level. At the governmental level. Not any appointee case then you take to international court. No, it's a country-to-country court. That's why most of the time, people leading countries, I think one of the successful people to be prosecuted is Milosevic. Slobodan Milosevic. He was, I think, Yugoslavia or so. And crime against humanity. He was prosecuted. Charles Taylor is also sent there and so on. These are people leading countries. But if the country is fast track court, then you take it to, hey, do you know how much it costs for the court to sit over there? The judges are not living in The Hague. They are living in their various countries. You empanel them, you buy first class tickets for them to come and sit. So if you go and waste their time, it's a whole cost. So just know that by Ghanaian laws, when the term ends in Ghana, Supreme Court, round 2, that is the appeal or the judicial review, it has ended. It has ended. Any other court outside Ghana, you are looking for what I will call emotional, support. People write their opinions and all that, but they cannot come and enforce anything in Ghana. They can't. What happened at the ECOWAS court? What happened at the ECOWAS court?
Oh, no, it's the Commonwealth that it's not.
No, I'm talking about, she went to ECOWAS first.
Yeah, it's still there. The case is still there. It has not been, they've not listened to the case yet.
But
the last time I checked.
How would ECOWAS actually enforce that law?
But since we are a member of the ECOWAS country, we are part of the ECOWAS. What I think they would have a saying. Or
yes, but yeah, that's what they say. Anybody can pronounce. But if the person does not, execute whatever, execution is different from the judgment too.
Okay.
Some of these things we are talking about, it is the goodwill of the people who ratify, hoping that because we have ratified, it has become part of our laws, and we would apply it. If you refuse to apply it, you cannot. What sanctions are they going to give to Ghana, especially ECOWAS?
Maybe they will put some trade sanctions on
you. Do you know the population status of Ghana in ECOWAS?
What's the status?
Ghana is next to Nigeria in terms of population.
Okay.
So taking Ghana out of your market is something that you wouldn't even want to do. In terms of the economy, in terms of population, Ghana ranks number 2 in ECOWAS. In terms of, the population of Ghana and then the GDP of Ghana ranks number 2 to Nigeria. So just know that your laws end at Supreme Court. Okay. So we are talking about let's move to the next one after the shadow director. So John, let's go on.
All right, sir. So we are now on 3.
Yes.
Subsection 3. So subsection 2 shall not derogate from the duties or liabilities of the duly appointed directors, including the duty not to act on the directions or instructions of any other person. Then 4, where a person who is not duly appointed director of a company holds out as a director or knowingly allows to be held out as a director of the company, or if the company holds out that person or knowingly allows that person to hold out as a director of the company, that person or the company is liable to pay to the registrar an administrative penalty of 250 penalty units. Then 5, for purposes of subsections 2, 3, and 4, a person who is described as a director of a company, whether the description is qualified by the word local or special, or executive, or in any other way, shall be deemed to be held out as a director of that company. Shall I continue, sir?
Yes.
Okay, then 171, number of directors.
Okay, so let me explain this one before we go to number of directors. So we are saying that when you look on for somebody to continue to be holding himself out, there is a penalty. 250 penalty units is about 3,000 Ghana cedis. A penalty unit is 12 cedis. So you only have to multiply by Ghana wants to move away from putting absolute figures in the constitution or in our laws. Some time ago, if you take the old laws, you will see, especially the police, MTT, their laws, you see that the fines over there, some were £2, some were £1, some were £5. Yes. And then very soon you see that because of inflation, you need to change those amounts and so on. So this time what we have done is to put penalty units, which is equal to 12 cedis. If we think that the 12 cedis is too low, you only change the penalty unit value. So now penalty unit is 25 cedis. So if it's 250, you multiply the 250 by 25 instead of 12. That does not affect the figures in our books, and this is more, civil in dealing with the fines instead of writing cash values. Okay, so there are a lot of places within this law that says if this shouldn't be done, if you do it, every officer who knows about it can be surcharged this number of penalty units. Then that's what we're going to read. For instance, if you are an officer and you are aware, you have a personal liability and so on. Yes. So we read that even though we talk about shadow director and their consequences, it does not also mean that if you need to find or get an advice from somebody as a board, then you are afraid to get advice because the person will be treated as shadow director. No. It is not a one-off thing that we are talking about. When we say accustomed to is an attitude or a behavior that is ongoing or that goes on for a longer period. It's not a one-off consultation with somebody for expert opinion that will put the person into the shadow directorship. Yes. So then we are saying that you go back to 171. Directors are those people or that person by whatever name called. By whatever name called is an interesting phrase to suggest that a director can be called different names. Different names. Director, regent, commissioner, governor, board of governors, board of trustees, board of this, board of that. But so when you say by whatever name called, the law is telling you that what you call the director, we don't care. If you want to call him chief linguist, these are chief linguists. We don't care. That's how you call them. You want to call them armed robbers, we don't care. The law doesn't care. But what are they appointed to do? They are appointed to direct and administer the business of a company. If that is what you have appointed them to do, then typically they are directors. So it's telling you that whether you have 2 or 3 categories of directors, and you call some local directors, foreign directors, so long as they have been appointed to do the same thing, they are directors. So the fact that somebody is a white man on the board doesn't make him a foreign director. He is a director. The Kodaki2 on the board is a director. So you can choose to call him local or foreign or roving director, but so long as they are appointed to do specific things, they are directors. Okay. Now go to the next one.
171, number of directors.
Yes.
A company incorporated after the commencement of this act shall have at least 2 directors, one of these directors being ordinary resident in Ghana. 2.
Okay. So
yeah.
Let me explain that. Ordinary resident in Ghana does not mean he must be a Ghanaian. Does not mean he must be a Ghanaian. He must have a personal, a permanent abode in Ghana. And it's, you know that at every point, there should be one director in Ghana. So if your directors are all foreign and they are living elsewhere, this is telling you that even residence is an important issue. If you realize that they are all living in Dubai, no director lives in Ghana. That is questionable. So there should be 2 directors when you are registering the company. There should be 2 directors. Minimum. As for your maximum, it depends on your pocket. I have seen the biggest last 2 months, I saw the biggest board. The biggest board ever I have seen was when they were inaugurating the tree crops. I don't know the full name of tree crops. Their board. There were 33 board members.
Wow.
33. That's the first time I've seen. I know a Nigerian bank, one of the Nigerian banks in Nigeria, they have 35-member board. But this one is a government organization with 33 board members. And if you have to take good care of every board member, you can imagine how much you spend. Okay. So usually boards are between 2 and maybe 15. Between 2 and 15. Okay. So let's go on.
2. If at then it's just showing the wrong document. If at any time the number of directors is less than 2 in contravention of subsection 1, and the company continues to carry on business for more than 4 weeks. After that time, the company, the director, and each member of the company that is in default is liable to pay to the registrar an administrative penalty of 25 penalty units for each day during which the company so carries on business after the expiration of the 4 weeks without having at least 2 directors. Then 3, every director.
So this one, you see it as if it's a joke. But it's in the law.
Yeah.
It says that, let's say, what most people usually do. They register the company with the wife. And then the wife will leave him. Or he will leave the wife. Let's say there's a divorce. And the wife is generous enough to resign as a director of the company. Now, Opana is left alone as a director of a company. But he's doing business. Now, once within 4 weeks, which is 28 days, if you don't go to Registrar General's Office of the Register of Companies to replace the director, and the lady has taken her resignation letter through the company secretary that she has resigned, and that has been filed, it means the company is working with only one director. It's doing business. After 28 days, every day that company does business, the board member, existing board member, and the shareholders, they will pay 300 cedis every day. They'll be charged 300 cedis every day. Every day. So if you have done business for 1 year, 300 cedis a day, you can imagine. So let's go on.
Then subclause 3, or section 3, I should say. Every director and every member of the company.
When we say member of the company, we mean the board shareholders.
Yes.
Mm-hmm.
So every director and every member of the company who is cognizant of the fact that the company is carrying on business with fewer than 2 directors are jointly and severally liable for the debts and liabilities of the company incurred during that time. And 4,
yes,
subject to this section, the number of directors may be fixed by or in accordance with the constitution of the company.
Okay. So it says that if you are aware that there is only one director of the company, or the company has no directors, and you are a shareholder, you are doing business, then every liability incurred by the business, by virtue of the fact that it doesn't have 2 directors, it becomes a personal cost. A personal cost to those of you who are aware. And you either have to share the cost or individually have to pay the cost. So that's, if you are serving on anybody's board, you have to be careful and you have to ensure that at least there is always 2 directors. There are 2 directors, and those 2 directors are properly filed. Sometimes you replace a director and it's not properly filed because there is no resignation letter from the other person who left. And the ORC will be waiting for that in order to file the new one. You can be caught by the same thing because within the 28 days, the right thing has not been done. Okay. Now, Liberals.
Yes, sir. Sir, please, in a situation where an organization is operating with only one director, that will come with these fines. Is it applicable to governmental institutions too?
Governmental institutions like which one?
For instance, DVLA, for more than 3 months now, the board has not been formed. It's recently that the board has been formed. So does it come with any implications?
It should, but the public sector boards are usually boards representing the president through the minister. So if you realize, most of the time when the boards are not in place, then you have to consult the minister to give approval for most of the things. Now you see why most of the presidential appointees are still in acting positions.
Oh, okay.
They are in acting positions because
yes, true.
Because at the time that they were being appointed, the Council of State was not in place. So gradually the Council of State will go back and approve all of them. Approve. And then they will clear the acting. Yes, so in governmental organizations, the appointing body is the shareholder, which is the government. And the government would always put in place an acting person, which will be the minister and the minister and his cabinet. I mean, every minister has his council, like directors who work in the company that he does his morning Monday meetings with. They would then be approving things in place of the ones that do not have a board. So they have something. The whole idea is to avoid one-man show for incorporated business, because an incorporated business has a limitation of liability. So you don't hide behind the fact that you are the only person running a company and affect people's money or suppliers' money with you. So they want a consensus to that effect. So typically, the governmental, a lot of things we read here, you realize that the government boards are doing something else. But who is going to enforce that? The ORC itself may be affected by that. But they are supposed to police. Okay. So let's go on.
Thank you, sir.
So now, appointment of directors and filling of vacancy. Mm-hmm. The first directors of a company shall be named in an application for incorporation. The person shall not be...
So when you look at it, first director of a company shall be named in an application for incorporation. Who will appoint them? Typically, looking at one, who should appoint them? That will be shareholders.
Yeah.
Because at that time, there is no managing director, so it's shareholders, or sometimes the promoter who is setting up the company will have to find some people to act as directors, otherwise it cannot cross to the level. Okay, go on.
2. The person shall not be appointed a director as a director of a company unless the person has been appointed A. Unless the person before the appointment A made a statutory declaration submitted to the company and subsequently filed with the registrar to the effect that the person has not, within the preceding 5 years of the application for incorporation, been charged with or convicted of a criminal offense involving fraud or dishonesty, charged with or convicted of a criminal offense relating to the promotion, incorporation, or management of a company, or a director or senior manager of a company that has become insolvent, or if the person has been the date of the insolvency and the particular company, and B, consented in writing to be a director and filed the consent within 28 days. 3, subject to this section and to section 173 and 174, the appointment of directors shall be regulated A, by section 300 in case of a private company, and section 325 and 326 in case of a public company, except as otherwise provided in the constitution of the company. 4, the constitution of a company may provide for the appointment of a director or directors by a class of shareholders, debenture holders, creditors, employees, or any other person. 5, despite a provision to the contrary in the constitution of a company, a casual vacancy in the number of directors may be filled by A, the continuing directors or director, although the number of directors may have been reduced below that fixed as the necessary quorum of directors, or an ordinary resolution of the company in a general meeting. Then 6, in exercising the power to fill a vacancy under subsection 5, the director shall observe the rules laid down in section 190 and 191, and shall not appoint a person to be a director unless the directors have taken reasonable steps to satisfy themselves of the integrity and suitability of the person to be a director of the company. 7, where the casual vacancy filled under subsection 5 is one which, under the terms of the constitution of the company, should be filled by an appointment by a class of shareholders, debenture holders, creditors, employees, or any other person, the director appointed by the continuing directors or by an ordinary resolution of the company in a general meeting shall cease to hold office as soon as any other director is duly appointed in accordance with the Constitution. Now, 8, in the event
that... Let's stop here.
Yeah.
So this is the mode. I mean, I told you that the appointment of a director is procedural, and it must follow something that will be accepted by the registrar of companies. So 1, you must be written to, and you must respond within 28 days. So if they want to be very difficult, even the letter that was written to you and when you responded, they would have to tell you to go back and write a fresh letter, because the 28 days is stated here. Then 5 years before you were appointed, you have not been charged of charge. Charge means police station charge you, the process is still ongoing, the court has not pronounced. Convicted means the court has pronounced. So even when you have been charged with something like dishonesty, and the case is ongoing and it has become slow, for the last 3 years, nobody has called you to court. It takes you back to 5 years. So 5 years after today, Have you been charged with fraud or dishonesty? Yes. Somebody can raise that you don't qualify as a director. Then anything involved in the promotion of a business, incorporation of a business, if you presented a forged documentation, if you also sold somebody's company that he asked you to promote, all those things you will not qualify to, be part of the registration of a company, a director of a company. Now, the director or senior manager of a company. So here, either you've been a director before, or even in your company that you work, you were a senior manager, and the company collapsed during your time. So it is not, you were a director of a company, the company collapsed. Yes. But it doesn't end there. It says senior manager. So let's say you have a microfinance, you work in a microfinance firm, and it collapsed. Like some collapse. When you want to become a director, anybody can raise that against you. Anybody can raise that against you. And the date of the insolvency must be within the last 5 years. If it's beyond 5 years, you may not be affected. But within the last 5 years. So those of you, anybody invites to serve on their boards, the company appoints you to the board, there's no meeting, nothing happens, they are doing their business, they don't care about you. They only put you together to show that they have a board. If the business collapses, it affects your future integrity. Your name will be part of a list of important board. Then the OIC would reject that name because you have been involved in insolvency. Okay. So the B says you have to consent to the letter written inviting you to become a director of a company.
Hello, sir.
In writing. The consent must be in writing. And you cannot ignore that. Yes?
Sorry, just to draw your attention, Section 172 clause 2 A, the aspect of having been charged, that aspect has been declared as unconstitutional by the Supreme Court. So now it's only the aspect on the conviction.
Yes, I remember the beginning of the discussion on that charge thing. Yes. But thank you for drawing my attention. I didn't get the conclusion there. But when it started, because the charge was seen as that one, it may end in your favor.
Yeah.
And it wasn't fair to talk about charging somebody because there are a lot of people who are charged on a daily basis. And I remember there was also a discussion on the fact that it may even be a wrong charge. The charge may not be actually dishonesty, but the police usually will give you a wrong charge. And eventually it may be thrown out or they may have to go and revise it. But you would have denied the person, the directorship because of that charge. Yes, so thank you for drawing my attention, yes. Okay, so as we, I think we're on the B. The consented in writing to be a director and filed the consent within 28 days.
Hello, sir.
Yes.
So please, I want a clarification on the difference between promoter and then shareholder.
A shareholder is an investor who has invested in a company. He may invest in cash or in kind, like you have a shop by the roadside and you want to do business, somebody wants to do business in your shop. You say, I'm not charging you rent. I want to be part of the business. So let's sell cement. Okay, cement. So my contribution is my shop. So you value the shop and it becomes part of the business. That is a shareholder. A shareholder is an investor, the one who puts the money together to invest in the business. Sometimes you call them equity holders. Okay. A promoter is like a consultant whose business, he's a businessman. His business is in registering companies for people, establishing the company. So somebody like Osama Kwame Despite, he wants to go into, let's say, rice milling. Despite will not come from Accra to Agra to do the rice milling. So somebody is charged, who is a professional promoter, to look for appropriate sites where we can build a mill and register the company, the number of bags we will need, number of bags of rice we will need to mill in a day in order to get this outcome or output that we are looking for. That person is a promoter. And when a person is a promoter, he has some responsibilities. But every information that he gets during the promotion, he should be able to give the information to you. Some people, once they get to know that you are going to build a rice mill, they come to you, the promoter, at a grab, and say that I have a rice farm. I shall supply this company at this price. And that is what we call the pre-incorporation information, which you must relay to the person who asks you to do the registration. In fact, sometimes you can even sell some of the things if the situation demands, and you are supposed to account to the person. So the promoter is not a shareholder. In Ghana, most shareholders try to register their own companies, but elsewhere, they don't worry their heads at all. They give it to other people to do it for them. And
okay, so I have another question too. So if I have a company and then I'm consulting a promoter to help me venture into another sector, must we sign any agreement?
A promoter is a business. So John, quickly move to section 10 and read it for him.
All right, sir. Scroll.
Section 10 is far away.
10 is duties of promoters. So 1, a person who is or has been engaged or interested in the formation of a company is a promoter of that company. A person acting in a professional capacity for persons engaged in procuring the formation of a company is not a promoter of that company. The promoter shall, until the formation of a company is complete and the working capital of the company has been raised, A, stand in a fiduciary relationship to the company, B, observe utmost good faith towards the company in a transaction with the company or on behalf of the company, and compensate the company for any loss suffered by the company by reason of the failure of the promoter to observe utmost good faith.
Okay, so
Then
here,
yeah.
a person who is or has been engaged or interested in information of a company is a promoter of that company. So you may be engaged by somebody, or even within your group that you are forming a company, you are the one following up to establish the business. Okay. Now, if you're an accountant, a chartered accountant, and you are working for let's say, Despite, and you are going to register a company on behalf of Despite, they say you are not a promoter. You have your profession. That's the promoter job is not your job. That's not your livelihood. You are not a promoter. You may be a lawyer trying to set up a business for your client. You are acting your professional capacity. You are not a promoter, and so on. And then you've been told the duties of a promoter. The fiduciary relationship means that you have, you stand in a very, of course, the utmost good faith is very close to the fiduciary relationship. You have a duty of care to deliver and then compensate the company for any loss suffered by the company by reason of the failure of the promoter to observe the utmost good faith. And utmost good faith is supposed to be a higher level of duty of care, even beyond ordinary contracts. Okay. So okay, go on.
No, so sir, it's just in that understanding that I think the question that liberals asked first as to then the distinction between the promoter and the shareholder, where in the Ghanaian context and for that matter under Ghanaian law, the law allows you as an individual to actually incorporate your own company without necessarily falling on these promoters. So in that regard, I foresee, or it is my understanding that the law then sees that promoter, after the incorporation, that is after the incorporation process is complete, is likely to become a member for that matter, by becoming a shareholder for that matter in that regard. Then the sharp distinction we are trying to establish between a promoter and a shareholder at that level may not exist.
Okay, so if for instance, if the shareholder acts as a promoter, right from the beginning, he's still a shareholder. Sure. Because he will still have to file his name as a shareholder right from the beginning. Unless he is doing feasibility studies for his group. Because if you look at the duties, it says that who is or has been engaged or interested in the formation of a company is a promoter of that company. But in terms of Ghana, the one who is mostly registering his own company, even though he is engaged in the duty of a promoter, in most contexts we don't call them promoters.
Yeah.
It is those we pay who become promoters. So that is why I was trying to let him know that in proper terms, the one that you want to call promoter is not the one within the company. But if you are in a company and you are engaged in the business of registering the company, then you will be able to come under the section 1. I mean the 10.1, because you are interested in the formation of a company. But that is not the kind of promoters that we deal with. Because, for instance, if you look at section 4, and Section 5.
Yes.
You realize that the person must be out of the company in order to deal with people in this way. So I think that he wanted to know whether he could use the term interchangeably. Yes, that's how I saw the question.
Sure. And sir, even the 5.
Yeah, sir, that's exactly the question I was asking.
Mm-hmm.
Yes, but sir, even the 5, when you look at the 5A, at the point of ratification, it talks of where that promoter, if that promoter becomes a director, or it says by the board, by the board of directors of the company, if all the directors of the company are independent of the promoter. So it envisages where you may be a promoter and a director, or you are not a promoter at all, like as in your earlier explanation.
Independent of the promoter could also mean that you don't have any dealings with the promoter.
Exactly.
Yes, because an independent director, well, if you have even worked with them before, you cannot be independent. If you had a previous dealing with them, you can't be independent. There are a lot of things that will not make you independent of the promoter. So the promoter himself, being a shareholder, will be part of it. But then there are a lot of, for instance, if you don't collude with him, if the director of the company are independent of the promoter, will mean that they have no relationship that is business-like of the promoter. But the ratification here, I think, says the 5 says a transaction between the promoter and the company may be rescinded by the company unless after full. So when you say a transaction between the promoter and the company, you should know the transaction we're talking about.
Pre-corporation transactions.
Yes. So that means that the people can choose to take the transaction that you have entered into, or they can go against it. And that is, I think, the case of the Kellner versus Basta. I mean, in the case law, yes. Yes. So,
on agency.
Yes. These are issues that the promoter may go into business behind the directors. And he thinks that it is in the, interest of directors. But if the rectification doesn't come, it becomes your personal cost.
Yeah.
Okay. So let's go back to our directorship.
Okay, sir. So 173.
Yes. In Ghana, promoters are usually promoters of music and concerts and those things. That's where we hear their names.
Hello.
Hello.
We didn't hear you. Say the promoters of.
I say Ghana, when you hear promoter, they are people in showbiz.
Promoting promotion.
Yes.
Like Baby Jet Promotions.
Oh, he's now a promoter.
Oh yeah, he has a promotion for boxing.
Oh, okay.
And then Mohammed Sharaf Muhammad as well.
Yes.
Yeah.
Yes. Those are the promoters we hear.
Don King. Legendary Don King.
Is he still alive?
I'm not sure.
No. Okay, then those who promote for girlfriends, if you want a girlfriend, somebody can promote you in Ghana.
Those people have a different name for them.
Dennis is fat. Dennis is fat. Dennis is fat.
Dennis,
yes,
Dennis.
At this moment, I'm projecting, so I won't speak.
Dennis, it says he's in charge of all the Accra ladies.
Yes.
They are pimps. They are pimps.
But he is protecting them.
Oh, okay.
So he knows
Thank you very much.
He knows the sleeping time of all the ladies.
It's not bad.
Okay, so let's go to 173.
173, qualification of directors. The following persons are not qualified to be appointed or to act as directors of a company. A, an infant. B, a person adjudged to be of unsound mind, a body corporate. A person who is prohibited from being a director or promoter of or being concerned or taking part in the management of a company as a result of an order.
Hey, somebody is talking. Somebody is talking.
Margaret.
Maggie, your microphone.
Sorry.
Okay. D, a person who is prohibited from being a director or a promoter of or being concerned or taking part in the management of a company as a result of an order made under Section 177, so long as the order remains in force, unless leave to act as director has been granted by the court in accordance with that section. And E, an undischarged bankrupt, unless the bankrupt has been granted leave to act as director by the court by which that person was adjudged bankrupt.
Okay.
Yes.
So, infant, of course, in our context, if you are not 18 years or an infant, you'll be considered here. You don't have the capacity. So, you will not be appointed as director. Then, if you are judged to be unsound mind, and that may be done by a court of competent jurisdiction, or wherever you get your information from. But usually, if somebody challenges, it is not mere doctor's report. A court must pronounce that, yes, they believe in a doctor's report. Then, a body corporate, a company cannot be a director. Even though a company has bought shares in another company, that company cannot be a director. A human being must go there as a director. This C, body corporate, is important here because when it comes to company secretary, a body corporate can be a secretary, but a body corporate cannot be a director. So take note of that. Then D. D is a person who is prohibited from being a director or promoter. When, you remember we talked about a person that, we didn't talk about it, yes. Sometimes you do something and the court would say that you can't be a director of a company for some number of years. And that enforcement is what we mean by the Section 177. The court has put a ban on you. And most of the Bank of Ghana may also restrict people, not in this law. The Bank of Ghana law is, when it comes to banking, their governance is different. Except the BOG law is silent, then you can come to the company's code. So, if you are at least fraudulent, the Bank of Ghana will sanction you, and you can be director of any rural bank or even collectors. In that case, they would not register you because they have sanctioned you. So sometimes the court will say for the next 10 years you can be director, or sometimes the court pronounces it. After 10 years you want to go back to court to appeal for them to lift that, and then they can lift it. And that is what they mean by the D. Then an undischarged bankrupt, unless the bankrupt has been granted leave to act as director by the court, which in Ghana, we don't usually have bankruptcy laws on persons. It can be on companies, but on persons, such that somebody has been declared bankrupt, and if you do business with a person, you do it. We don't have those, clear laws. Therefore, unless you have been involved in a certain company that has been declared bankrupt, it doesn't make you bankrupt in any case. So usually those ones are made as executory, provisions. In case those laws come, we already have it in place. And that will not mean that it's a retroactive law. But remember that most of these provisions in these laws started in 1961, where Professor Gawa put together the Companies Act 179, 1963. So we still have some of the common law issues in some parts, which we are gradually cleaning. Yes, so there are people the courts will tell not to be directors. I know about 2 people, but I can't mention their names here. One of them sold generators to his own company and inflated the prices. So he was banned by the courts not to be a director of any company. It was a huge amount of money, because they supplied generators across the country to a company that he himself was affiliated to. And the inflation was too huge. All because he was also part of the people who influenced the check to be written. So there was a clear conflict of interest and also fraud. Then another one also was banned from becoming a director because he forged the signatures of other directors and signed a resolution as if the board signed a resolution. And based on that, he perpetrated a certain act. Yes. Let me go back to explain. When we say ordinary resolution, we mean what we usually call majority carries the vote. Majority carries the vote. So ordinary resolution of a board means that at a board meeting, majority carried the day. So when you have an election and its majority carries the vote, that is ordinary resolution. But when you have any voting where they say 50% must vote for, and you don't get the 50%, or 2/3 of members at the meeting must vote in favor, then we're talking about, if there are 100, we're talking about 67%, because 2/3 of a human being cannot be fraction. So 66 2/3 is 2/3 of hundreds. And then, so if it's human being, instead of 66, we make it 67. That is a special resolution. Anytime the resolution is qualified as special, then there is a cut-off point that you must achieve, which is usually higher than the ordinary resolution. So if it says a resolution should be passed, usually it's an ordinary resolution. If they don't qualify it as ordinary, usually it's ordinary. But if it's a special resolution, Then they will give you 3/4 of the people present, 2/3 of the people present, and 60% of the people present, or 80% of the people present must vote in favor. That becomes a special resolution. Okay. Now let's go to 17. Yes?
Please, I'm sorry to I have a simple question. What about convicted criminals under what we just discussed? I think they should also, I mean, convicted criminals, yeah, should be exempted from being directed.
There should be from the D, yes. Yes.
Okay, sir.
Because the A doesn't talk about them, the B doesn't talk about them, the C doesn't talk about them. It says a person who is prohibited from being a director or promoter of being concerned or taking part in the management of a company as a result of an order made, so long as the order remains in force, unless leave to act as a director, and leave here means permission from the court, has been granted in accordance with the section. So these people will not be qualified as directors. But you remember that 171, where we talked about the ex-convicts. So we have what we call the combined effect. The combined effect of the 172 and then the 173. You have to combine them and select your directors from those who are not affected by any of them.
Okay, doctor.
Okay.
Thank you.
Okay. Now let's go to 1-8. Yes.
Hello, sir.
Yes, go on.
Okay. With point C, if I heard your explanation well, you said with regards to the person being of a sound mind cannot be determined by the doctor's report alone, but it must be confirmed by a court or a judge.
If the person challenges,
how can a court determine? Okay.
A court has processed.
So if there is no challenge, it means that can be used from the. Okay.
If the person you are appointing, you are told that the person has no sound mind, and the person walks away, you have no problem. But let's say the person has a share qualification that allows him to be a director, and he is pushing to be a director, and you are saying that in spite of the fact that a shareholding qualifies him to be a director, you have evidence that he is unsound in mind. You think the doctor's report, you cannot get a doctor's report in the first place. So eventually, the case must end in court for the court to determine.
Okay. All right. Thank you, sir.
Oh, sir.
So how are you going to tell him that he is not sound in mind? How will you tell the person whose investment is more? Yes, let's say 51%. How do you tell a person who has invested 51% in a company that he is not sound in mind?
Initially, I had it in mind that when it is well known that maybe the person is not in good shape or unsound mind to lead, you can just put it out. But like I have explained, if the person also come back to challenge, then it means it has to end in court for determination.
I'm saying that you think the person accepts that he is not sound in mind. He doesn't accept.
And if he doesn't accept that one, unless you terminate the person's contract, no matter the percentage he holds in the company.
You think that if our president, you see signs that he is unsound in mind, you think you can just appeal to him that he should resign?
No, please. Unless it's sent to court.
So, yes, and there are people who are also applying to be president. We are not testing their minds, but we know that those people, some of them, they really are not in good shape up there. So one day we will vote for a mad person until we get to a point.
Can it be?
We'll get to a point where
then will it be fair?
Before electoral commission will register you, you have to show your mental health certificate.
That's exactly what I wanted to ask.
Yeah,
so
but we may not even get anybody to stand. Yes, there was a lady's hand up. There was a hand up. Please ask your question.
Hello, sir.
Yes.
So I know this board of directors, they don't take salary.
Are you a lady or a man?
Sir, I'm a man, sir.
You're using a lady's account. Okay, go on. Before.
Okay, so let's
Dennis comes in.
Okay, so let's use DVL as a case study.
Mm-hmm.
I know the board members don't take salary, but I want to know how their remuneration come by.
Okay, so one of the things we have not talked about is that when you are registering a company, you must have a constitution, a company constitution. So the company constitution is written by the owners of the company as to how they want to be governed, or they want the company to be governed. It cannot override anything law, like anything in this document we are reading. It cannot override anything. But anything that it puts there that is not affected by the laws here, or where the laws here give them the room to operate, like the upper ceiling of directors. You see, this law gives the minimum directors as 2. It doesn't give the maximum. It expects that your constitution will give the maximum for your company alone. Another constitution will give the maximum, and so on. So, the constitution of the company, if you don't have one, you haven't written one, that will be filed as part of your documents. Then, the company's register of companies will give you a default one, which they will usually add to your incorporation certificate. So, depending on what you have in your company's constitution, we used to call it the regulations. How you pay your directors should be in your constitution. So there is, some of them will tell you a certain allowance, blah, 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 blah. They will state it there. And then the board fees. So the board fees will maybe become quarterly as something like salary. Then the certain allowance as and when you sit. And usually it is merely a refund of the cost you incurred by attending the meeting. Let's say you live at Afram Plains. Afram Plains, you are a council member of KNUST. You come to board meetings. Your accommodation overnight, or if you spend 2 nights, let's say you came, the meeting ended around 6, you can go to Afram Plains, so you slept again That shouldn't be your cost. So the city allowance in some companies is like somebody's 1 year salary. Yes. But the city allowance is an inconvenience allowance for you to come and then you've left certain things you are doing and you have come and you are supposed to be compensated for the loss of profit if you were a business person and all that. But then there are different conditions for different payments. Sometimes when the board has also done well and they have increased the bottom line of the company, some constitution of the company will say, if we're able to achieve this level of profitability, board members must be, motivated. But that motivation is in the constitution, but no amount has been set, and some people can abuse that. So some of them would also put percentage points. If we're able to achieve 5% more than the projected, profitability, then the board would share this percentage out of that extra. So is that usually how you don't know how they are paid?
Doc. No, sir, I don't know how they are paid.
Okay, so they may be paid.
Hello, Doc.
Yes.
Oh, please, it is break time.
Okay.
The break.
Okay.
We are supposed to go for break at 10 o'clock, but now it is 11.
Okay. So
Okay.
we'll break soon. Yeah. So they may consider paying themselves through the certain allowance they get.
Okay.
It's an authority, isn't it?
Yeah, it is.
If it's authority, they are usually able to pay bigger board fees or city allowance. Okay. Authority means that they are self-financing. They pay. They are able to pay their own salaries and so on.
Yeah, true.
So usually, government is not too worried about the authorities, but they are worried about the subvented organizations that takes money from government for everything, and they themselves don't generate any income. And if you serve on such a board, you don't get anything. But the authorities, they are internal generated funds exist for them to be able to pay unnecessary things, and that includes increasing the board, salaries. Some boards even have cars for their chairpersons. Some have offices for their chairpersons and so on.
Yes.
And the argument is that he doesn't live in Accra. He comes because of the board meeting. So some of them give them a guest house, like one of the company bungalows is allocated to the board chairman. So they are doing a lot of things on the, so people envy some boards. If you want to appoint him, he wants specific boards because they are very juicy. Yes, but somebody must also work in the board. Some boards, if you go there, if you don't take care, you use your money to solve problems. Somebody.
Sir, please, last one.
Thank you.
Sir, please, last one.
Okay.
So if I have an organization or a company and I capture in my company constitution that I want to pay my board of directors monthly, more or less like salary, is it ethical or is it unethical?
You want to pay them monthly?
Yes, sir.
For doing what? For doing what?
For giving advice or for engaging them as board.
The payment doesn't matter. You see, if you intend to pay them, let's say 3,000 at 3,000 Ghana cedis.
Okay.
For sitting allowance, and you decide to spread it and make 1,000 every month. It doesn't matter. It's the 3,000 that is going to them.
Okay.
Yes. But if you are paying them monthly, it means that they are working for you every month. But if you are paying them post the board meeting, and you say they are entitled to 3,000 cedis, but how you disburse the 3,000, knowing the company's strength, that we can't pay 3,000 at a go, but January we pay 1,000, February 1,000, March 1,000, and it is said to be board sitting allowance, because the internal revenue must know what you are doing. The GRA must know the kind of money you are paying, whether it's taxable or not. You understand?
Yes, sir.
Yes. But if you start paying them before the first board meeting, then, any auditor will question that.
Okay.
Okay.
Thank you.
Okay, so let's start. Yes.
Well, just to add to his, I know some boards pay quarterly because they are very sure that there will be board meetings within every quarter. So they just accumulate the sitting allowance and pay them quarterly. That's after the board meeting.
No, the sitting allowance is after the board meeting.
Yes.
And by law, every board should meet minimum twice a year.
Okay.
But at least there should be, usually they meet quarterly, mostly quarterly. So if you are paying quarterly, you can't pay, let's say the first meeting is in March.
And then they don't
you can't pay January to March.
Okay, exactly.
You can pay after March.
After the next meeting.
Yes. And then there is, you can have a sitting allowance, and you can also have a board fees. A board fees. That is more like a lump sum that you give to the board members like salary. If you have the strength to pay, you can pay that separately.
Okay.
Then you can give the sitting allowance to them after the meeting, and then the board fees you can spread. I have seen somebody, a government appointee, who has no knowledge about banking, but she was on one of the state banks board. So when it is meeting time, she comes early morning by 9. The meeting is starting at 10. By 9, she's there. And when she comes to sign that the first lady is going somewhere with her, so she won't be able to attend the meeting. But she comes to sign for her sitting allowance. Meanwhile, she's not going anywhere. By lunchtime, the driver will come back with her nice bowl for her lunch. And then 6 bottles of beer for her beer.
Okay.
I said if she was at the meeting, she would drink 6 bottles of beer. Yes. So she doesn't attend the meeting. She's a government appointee. She doesn't attend the meetings because she has nothing to offer in terms of the banking.
Yes.
So
and
she only comes to take the money.
Okay. Sorry to interrupt. To add, I think receipts of fuel for the members who travel and their accommodation, some boards, not some boards, I think there are requirements so that the board is able to reimburse them for members who come from afar, because naturally not all members will come from the same distance. So all that I'm very sure is included in how they reimburse, they pay them.
The point is, it's accountability issue. the auditors will ask. You see, whilst you are paying board members, the board members are not above accountability. You understand? So if we say you bought fuel for them, where is the receipt? If you give them money to buy fuel, where is the receipt? So it is the auditing that request for that, especially if it's a government organization. If it's a private organization, they probably don't even audit the company and they may not bother. The way they have what you call creative accounting, how they will cover that, nobody knows. A government organization, then you have to do the needful. And sometimes your name can be mentioned in Parliament if you are not following the financial administration law. Yes, so even the board meet fees, they sign for it. They sign for it. Every money you take from the organization, there should be evidence that it was taken. If they bring it to your office, especially a board chairman, they probably bring it to your home or your office for you to sign and take it. Maybe you feel too big to wait for the accountant. And sometimes the accountant will be at the board meeting. Envelopes are ready. By the time you finish your, after board meeting, there is food. Sometimes, by the time you start eating, they've taken their envelopes. And then they'll eat there and do some takeaway. So some of the boards, they are juicy. Very juicy. And some of them too, they are hell. When you go there, say, this board, people have been talking about me. I'm on this board, but I'm not seeing anything. Then you realize that the godfather who put you on the board did not fight for you well. Okay, so let's have the break for...
So before you go on break, my last question. So, like you said, some of the boards or some of the institutions are very technical. How can you appoint somebody on a board of which you may not have any idea or technical knowledge about the board that you are going to be part, especially with regards to the bank that you said you are on the board of which you don't have any knowledge? Are there laws guiding the board appointment?
So, before you answer that, maybe I'll tie this in. There are institutions that are same technical, and per the laws establishing those institutions, there's a requirement for the qualifications for appointment. Now, there are still institutions where even the appointment of the MD is specified in that law, but then the managing director does not have the qualifications but still appointed by the government. And then the government is the same person who appoints the board chairman, who is also not a technical person as required. In such circumstances, what can be done, or what comments can you make?
Okay, so in many cases, the job of a board is not only technical. The job of a board is not only technical. Some people are there to point out, things the way they are. So sometimes you find a chief on a board. The chief may not be technical, but he has some conflict resolution skills. So when there is heated fire, then he comes in, another nice so. Then everything is like our local things. Some are MPs, they have no technical knowledge. Some are pastors, they have no the technical knowledge is not a requirement for everybody on the board. A lawyer serving on VRA board may not have a technical knowledge of the generation of power. But it pays to have an engineer, electrical engineer for that matter, or even mechanical engineer, because VRA is also very mechanical, as part of it, to understand whatever reports that come. Somebody must explain it to the board members. But there will be other people who are environmentalists. If they are on the VRA board, it's not out of place. If somebody who is a hydrologist, if he's on the VRA board, it's not out of place. So it is not only technical. Now, some of the things you are talking about are the political ones, like the person, you hear his name, he chairs or he is the CEO appointed to this one. I've seen some people questioning some of the appointees, and yes, when Parliament decided to cure this, they started by saying that the board chairman will be appointed by the president. No qualification. The board chairman must be appointed by the president. One person from, let's say a bank, from Bank of Ghana, not below the rank of a director. That person is supposed to be a technical person. But even how they couch it, not below the rank of a director, does not mean that he is a banking supervision guy. It could be a person from the research unit who has not gone through banking, but he's a researcher. He holds a PhD in research, and he has been in the research unit since he joined the bank. When you ask him about monetary, whatever, he doesn't have any clue. But the Act says a person from Bank of Ghana not below the rank of a director. Then they can say a deputy minister, one deputy minister of finance. Does it mean he's a technical person? No. It doesn't mean he's a technical person. He is the deputy minister of finance, but it doesn't make him a technical person in banking. Somebody like Setepe was a minister of finance, but he was a tax expert. Banredu was a minister of finance. He was a chartered accountant. It doesn't mean he was a banker. So when you're taking him to a Bank of Ghana board, he's not going there purely with banking knowledge, but accounting knowledge, or tax knowledge, or this, or that, or that. So when the Act is saying one person from here, not below this, one person, then they say 3 people from the private sector, one of whom must be a woman. So private sector will choose people to come. They don't necessarily have to be technical. Are they fulfilling the Act and its requirements? One of whom must be a woman. It doesn't talk about qualifications. They will hardly talk about qualifications in such that, but if they think, they will say one person from Ghana Institute of Engineers, or one person from Pharmaceutical Society of Ghana, or Pharmacy Council, and so on. One person from Food and Drugs Authority. But they will not mention the person with a qualification or a background of ABC. Unless they want, usually it is a lawyer that they will mention, a person who is a lawyer, or a person who is a medical practitioner, or a person who is a professional accountant or chartered accountant. Otherwise, when it's government appointee, it gives them room to appoint anybody at all. And sometimes they know the person cannot deliver, but he has been a loyal follower, and he can go and make some money. They don't care about delivery. And there are chairpersons of companies whose chairmanship, you can't talk. Others are running the show. Over to the no, Kagunasum, Cafe. And they are running the show. It depends on who is also calling the shots. I have seen CEOs of government organizations, CEOs who are more powerful than the board, that the CEO can tell the board members, I can let the government dissolve the board. And the board members are shaking. And the board was truly dissolved. Then I've seen board members, especially chairman, who is very powerful, that the CEO is afraid of. And is always returning to the person. Sometimes one person sitting on the board is so close to the president that even the chairman, the CEO, everybody is afraid of him. He becomes the center of attraction because he has the ear of the president. And anytime he's at a meeting, everybody wants to tell him their problems. More powerful than the chairman of the board. So these are, network issues. And you get to serve on the board not because of what you know. After all, at the end of your 4 years, you don't write any exam to say that at the board he did this or did this or did that. So will be a kubi. Okay. Let's have a break and return in 15 minutes. This one, you are home, so whatever you want to eat, let's return in 15 minutes and let's okay, so corporate governance has a lot of definitions. So I will not bother myself. With that. So I know those teaching the mainstream corporate governance have given you enough. But what we are interested in is the fact that most of the aspects are ethical in nature, even though the legalities are also there. But the ethical issues sometimes are the ones that put people in trouble. The conflict of interest matters, and so on. Some of them are really ethical in nature. But at least the conflict of interest is embedded in the governance, corporate governance, and in the act, as we probably want to look at later. So the corporate governance is an important factor in terms of running a company. It is not only about companies, but the major area that we care about is directorship in companies, especially the private sector. Until 2019, we were using the old Act, which is the Act 179. And that was from 1963. The current Act is about 90% what was in the old Act. Okay. So the governments usually will care at the top level of companies. And those that are active are the management, the board, and to a large extent, the shareholders. And many a times, the shareholders are hidden. Those that are very visible, the management, and sometimes the board. As I said, the board is supposed to run the business. And the board puts management in place to do the day-to-day running of the business. So corporate governance is the interaction between various participants in shaping corporation's performance and the way it is proceeding towards. The relationship between the owners and the managers in an organization must be healthy, and there should be no conflict between the two. Of course, this is on paper. That's when you're dealing with human beings. There isn't such thing like no conflict. There will be conflict whether I like it or not. So it's therefore about what the board of a company does and how it sets the values of the company, and it's to be distinguished from the day-to-day operational management of the company by full-time executives. So there are full-time executives who are employed to address day-to-day activities. Companies have drawn responsibilities, and the board also gets into some of the company running, who appoints the chief executive and executive officers, and so on. So all these, I think we shall move faster. Shareholders invest in a corporation or company by buying its stock. When you hear stock, we are talking about American English. In British English, we talk about shares. And they receive economic benefits in return. Shareholders are not involved in the day-to-day management of business operations, but they have the right to elect representatives, directors, and to receive information material to the investment and voting decisions. Shareholders should expect corporate boards and managers to act as long-term stewards of their investment in the corporations. Accordingly, shareholders should not expect to use the public companies in which they invest as platforms for the advancement of their personal agendas. or for the promotion of general political or social causes. Okay. I'm moving very fast. Some of them are self-explanatory. I don't want to bother myself with the issues that are self-explanatory. The board composition. And this may be in your company's constitution. How you compose your board may be in your company's constitution. Every company should have at least 2 directors. That's the minimum. All the directors must not necessarily be resident in Ghana. The law requires that one of the directors must be ordinarily resident in Ghana. So this something we discussed. It is therefore an offense for a company to carry on business with less than 2 directors for more than 4 weeks. The composition of the board should reflect a diversity of thoughts, backgrounds, skills, experiences, and expertise, and a range of tenures that are appropriate given the company's current anticipated circumstances, and that collectively enabling the board to perform its oversight function effectively. So just before we went on break, we were talking about composition of boards by governments without any serious considerations. Here we are saying that the composition of the board should reflect a diversity of thoughts, backgrounds, skills, experiences, and expertise, and so on. So you should be looking at all those if you want an effective board. A board tenure, how long you want the board to operate, is usually in your constitution as well. So the constitution talks about whether it will be 3 years or 4 years or 5 years renewable, and so on. So directors with a range of tenures can contribute to the effectiveness of the board. Okay. Recent additions to the board may provide new perspectives, while directors who have served for a number of years bring experience, continuity, institutional knowledge, and insight into the company's business or industry. Many boards do not permit people above certain ages. Okay. So we talk about composition and we talk about the importance of diversity. So a board should develop a framework for identifying appropriately diverse candidates that allows the nomination or corporate governance committee to consider women, minorities, and others with diverse backgrounds as candidates for each open board seat when the vacancy exists. Diverse backgrounds and experience or on corporate governance boards, including those of directors who represent the broad range of society. Strengthen Where is the board performance and promotes the creation of long-term stakeholder value, shareholder value, rather. Currently, most boards encourage women as members. Board size. So these are definitions you come across. Board size. In determining appropriate board size, directors should consider the nature, size, and complexity of the company, as well as the stage of development. Larger boards often bring the benefit of a broader mix of skills, backgrounds. Okay. So if the board is large, a broad mix of skills, backgrounds, and experience, while smaller boards may have or may be more cohesive and may be able to address issues and challenges more quickly. However, in practice, the following serve as a guide. Large listed companies, 9 to 15 board members. Medium size, 7 to 11. SMEs, 3 to 7. Large charities, 8 to 12. Then, small charities, 6 to 10. Public sector, 9 to 13. And university board, 15. So the board of directors is the primary direct stakeholder influencing corporate governance. Directors are elected by shareholders or appointed by other board members, and they represent shareholders of the company. The board is tasked with making important decisions, such as corporate officer appointments, executive compensation, and the dividend policy. In some instances, board obligations stretch beyond financial optimization, as when shareholder resolutions call for certain social and environmental concerns to be prioritized. The pre-qualification of a director. We've gone through this. Convicted of a criminal offense involving fraud or dishonesty. Convicted of a criminal offense relating to promotion, incorporation, or management of a company. Being a director or a manager, it was a senior manager, of a company that has been insolvent, or if the person has been, the date of the insolvency and the particular company. Then we talk about consent to the letter in writing. We have also discussed the disqualification of a director, where we talked about the body cooperating funds and undischarged person is I gave you different names that we can call directors, but they are not exhaustive. You can add your own. And it says whatever name you call them, so it can be any name. And when you have been written to, and you want to accept the directorship, first find out from the company if there is an age limit. If you are getting older, confirm the correct mode of appointment that it has been used. Written letter to you for you to reply and for okay. Check if there is a shareholder agreement on the mode of appointment. Some shareholders agreement, the two of them must agree, or if there are three. Check if the person to be appointed is not prohibited from acting as a director. That was section 177. Check whether prior approval of any regulatory body is needed. For instance, Bank of Ghana, or any body that needs prior approval, you need to check. No person shall be appointed a director of a company unless he shall, prior to such appointment, have consented in writing. Okay. So you can company secretary. Required to appoint a company secretary duly qualified under the Act to perform the duties of a company secretary. So the directors of a company shall not appoint a company secretary unless that person has obtained a professional qualification or tertiary level qualification with an offering in company law practice and administration that enables a person to have the knowledge and perform the functions of the company secretary. Has been appointed a company secretary trainee or has held office under a qualified company secretary for at least 3 years, or is a member in good standing of the Institute of Chartered Secretaries, and so on. Having been enrolled to practice, is in good standing as a barrister or solicitor in the Republic. By virtue of academic qualification, or as a member of the professional body, appears to the directors as capable of performing the functions of the company. The company secretary is responsible for the company's legal and regulatory compliance. The role involves maintaining the company's registers, keeping the minutes of the board, setting agendas, and keeping up to date with regulatory changes. Sometimes your board minutes may be called into evidence in a court. So you have to keep your minutes well. The day you are not expecting, you see that the court is asking you to bring the minutes to court. Sometimes you are now looking for somebody's copy. In a broader sense, The company secretary is a trusted advisor to the chairperson. Sometimes you have to guide the chairperson, especially if he doesn't know about meeting procedures. He provides valuable direction on the company's values, mission, purpose, and governance. Quashie-Sam takes minutes of meetings and provides advice on procedural matters. The secretary usually has responsibilities for liaison with shareholders and the government registration process. Okay, ethical responsibilities of a director. The fiduciary relationship, we've talked about that. You must act in ultimate good faith. This ultimate good faith is very common in the insurance industry. And if you are working in those areas, you must exercise the utmost good faith.
Hello, Doc.
Okay. Yes.
Yeah, please. We are supposed to end at 12:30. I don't know. It is 12:30, so that the next class.
I have another class at 1, so I just want to end this slide and we'll stop here. Tomorrow, are we starting in the morning or afternoon?
Sir, unless I confirm on the timetable, so that
okay.
I'm sure we'll start in the afternoon. I'm sure.
Okay. So
we'll start in the morning, sir. Yeah.
Okay. Okay. So as I said, let's finish this slide. The director stands in a fiduciary relationship with the company. And that means that the director holds a position of trust and confidence. And as a result, the director is an obligation to act solely in the company's interest. Company's interest. So, this, by extension, the director must act in utmost good faith. This is what we call the contract uberima fide in insurance. Utmost good faith. In relation to the company at all times, and always act in what he believes to be the best interest of the company. In more specific terms, the director should act in order to preserve the company's assets, further the business, and promote the purposes for which the company was formed in a manner that a faithful, diligent, careful, and ordinary skilled director would act in the circumstances. A director is prohibited from taking the assets of the company for his personal use or benefit. And according to the new companies, a director should avoid conflict of interest. And where that is not possible, where avoiding conflict of interest is not possible, directors must disclose all such interests in the company that is likely to create a conflict of interest between the director role and the company. So, if you disclose this contract, I'm chairing, my wife has applied, and I think I'm not competent to chair when my wife's application is in here. Therefore, I'll recuse myself and somebody else will sit on it. Okay. So, we would stop here. And tomorrow, we will start from the role of the board of directors. Okay. Let me, so we can stop here, and then if there is a question, I can address that before we go. Otherwise, I have attached the slide to, Please download it before you sign out. And I wish you all a happy weekend.
Hello, sir.
Yes.
So please, mine is not a question, is just a small consultation.
Okay.
All right, sir. So if I have an organization, would you advise that I'll operate on the supervisory board or I should operate on the management board if I'm a founder of the organization?
What organization is it?
So I don't have it yet. It's in mind.
No, we should even know what you are doing and all that. Sometimes, depending on what you are doing, you probably will need some guidelines as to the kind of every board that you want to deal with has the same responsibilities. It is an oversight towards the management. And if you want to have more corporate, members, then your executive directors will be more. But if you have more executive directors, you should ask yourself, do you have a powerful managing director to deal with the corporate or the executive directors who are also sitting with the person in the boardroom? So when we know what we are doing, it's better. But if you don't want to know.
Okay, so sir, let's say shipping.
Shipping, you haven't said anything.
So let's say
are you running? Do you have a ship that you are running, or you are only?
No, let's say
a carrier.
No, let's say I'm into shipping and logistics. Inbound, yes. So, let's say overseas. I do export overseas, and then I import from overseas too.
Okay. And who are your clients?
So, this thing is not an existing company. It's just a case study.
Oh, okay. For me, if you are setting up a business and you expect the business to grow, I prefer that you set up a supervisory board. And then because the business will grow. And the executive will be out of hand, especially if it is, not an owner-manager business. If we want the administrative management, it's more or less very narrow. You understand?
Yes, sir. Following.
But if you want to make it some people have established limited liability companies and are operating like sole proprietor. They're operating like sole proprietor. It's a limited liability company. He pretends to have a board, but he takes his own decisions. When the board member draws his attention, you won't hear from him again. There will be no meeting. And then you advise yourself and so on. If right from the beginning you have corporate governance in place, and then you know that yes, you are the owner, you appointed a board over you. You are willing to listen to the board and ensure that the board has oversight responsibility or supervisory responsibility over the executive. Otherwise, when the company is growing and you are now trying to put things in place, you realize that you, as the CEO, you have not learned to listen to people.
Yes, sir.
When your money was small, nobody advised you. You were rather telling your board that you know what you're about. So you learn these things from the beginning, and at every point, that will help you grow. One of the things that companies don't know is that when you are starting a business, you make a lot of mistakes. Open a bank account, put the money in the bank account, and operate from the bank account, so there will be track record of your history, your banking history, and how you spent the money. You see that you are spending from your pocket. Every time he buys something for the company from his pocket, the company account has not been created. And after that, you want money, you want to take a loan to support what you are doing. The bank is telling you that your banking history is very infant. Meanwhile, the money you use in building the company, if you were drawing it from the account, it would have been counted. Okay. So as I said, I also have another class at 1. So
thank you, sir. Thank you so much. Thank you.
Okay. I hope you have taken the slide, so I can shut down now.
Hello.
Yeah, hello. Yeah. Good afternoon.
Afternoon.
Ali?
Hello. Hello. After a good afternoon, I didn't hear anything again. No?
Doc, sorry, it's not here. Sorry.
Okay. There was a lady's voice. Let me listen to that.
Yeah, I was just saying I have downloaded the slide.
Okay.
So thank you. Yeah.
Okay. Take care.
Okay. Tomorrow.
Tomorrow. See you tomorrow.
Okay then. Bye.
Bye.